Well, good afternoon, everybody. Welcome to today's webinar on defamation law and social media. Some housekeeping matters just to tidy up first. We're hoping to be able to do a relatively informal webinar today. We encourage people to submit questions if they wish to. Don't be shy. Um, if you do decide that you wish to submit a question, it will show up on Sam's and my screens, but none of the other participants will see the questions. We will endeavour to respond to your questions as part of today's presentation. Rest assured, though, that if we don't get to particular questions, we will certainly respond separately after today's webinar. The other thing that I would also mention at the outset is that I am going to just start by discussing in very general terms what defamation is and why it's relevant in the social media space. The first thing I suppose I would say is that defamation is when a disparaging comment or remark made about someone and that is published to a third party. Normally, defamation is by spoken or written words. In this online world in which we all live, it raises the question of, well, where and how does publication of defamatory material occur in the online space? We have some guidance from the court on that. It goes back to a decision of the High Court in the early 1990s involving Joe Gutnick. Joe took objection to an online publication by an entity called Barron's. Barron's online financial publication, which was owned and controlled by the Wall Street Journal. There was some material in a particular edition of one of the Barron's newsletters, which he considered to be defamatory of him. He commenced defamation proceedings in Victoria, Australia. A point was taken against him by the Wall Street Journal, or Dow Jones, the correct name of the publisher of the Wall Street Journal is. They said, well, this material was prepared in Washington and it was uploaded to a server in New Jersey. So the Australian court has no jurisdiction to hear the defamation claim. That ultimately went to the High Court, and the High Court said that in the case of online publications, publication occurs when the material is downloaded and read on a particular device or computer of a user. So because there's evidence to demonstrate that people in Australia had actually downloaded the relevant Barron's publication and read the material Mr. Gutnick took exception to, the court said publication had occurred in Australia, therefore the Australian courts had jurisdiction to hear the defamation claim. So that's how defamation is treated in the online space in terms of publication. We've had a few questions actually submitted to us by some participants in advance of today's webinar, so thank you for that. One question that I'd like to deal with now, because it's convenient to do so, is that somebody has asked whether or not there is a defence in defamation law of truth or honest opinion. And that's a good question, and I'd just like to address that now if I could. I've practiced in defamation law for about 20 years. One thing that has become apparent to me throughout the course of my involvement in defamation law is that I don't think it's really about protecting somebody's reputation. I think it's more about freedom of speech. And why do I say that? Well, I say that because it's relatively easy to prove that somebody has been defamed by a publication. A really hard part is to defeat the numerous defences that the law of defamation provides. And to answer the question posed by one of the registrants, yes, there is a defence of truth. In the old days, prior to 2005, in Queensland at least, you not only had to demonstrate truth, that what you had said was true, you also had to demonstrate that there was a public benefit in publishing the defamatory material. The public benefit test has been abandoned, so it is enough if you can demonstrate that what you said was true. The really tricky part is that the defence of truth will only succeed if you can prove that the defamatory meanings that the plaintiff alleges were conveyed by the publication were in fact true. What do I mean by that? Well, if, for example, a newspaper article is published that says that person X was observed acting suspiciously in the vicinity of a robbery, the plaintiff commences proceedings, defamation proceedings in respect of that article, and she says, the meaning conveyed by the article is that I did the robbery. So while as a defendant you might be able to prove that this person was actually observed in the vicinity, was observed to be acting suspiciously, you are basically stuck with having to prove that the actual robbery was committed. So truth defence it's not as simple as it sounds, I suppose is the point that I'm making, but rest assured that there is a defence of truth in defamation law. It's just like a lot of things in defamation law, it's a bit complicated sometimes. The other question that the same person has asked is, well, is there a defence of honest opinion, or what's sometimes called fair comment? Once again, the answer is yes. But once again, there are some technical issues that are associated with successfully establishing that defence. Defamation law protects opinions if they are honestly held, provided the facts on which the opinion is based are either set out in the publication or are sufficiently known by the readers, the people who read the defamatory material, are sufficiently well known, as I say. So once again, it's a technical defence, and a good illustration, a recent illustration, was the recent defamation case that was brought by Elaine Stead, a venture capitalist, against the Fairfax media and Joe Alston. Joe published a series of comments or articles in the Financial Review, which were highly critical of Ms. Stead. He relied upon the defence of honest opinion, but where he fell down was that he was unable to prove or demonstrate to the court's satisfaction that the facts that he was relying upon to express those opinions were set out in his articles or could be accessed by other sources and were known to the readers. So while he was able to demonstrate some of the facts, he wasn't able to demonstrate them all. As a result, Ms. Stead succeeded with a defamation claim. I think she was awarded about $380,000, but Fairfax was also awarded to pay costs, and those costs will be in hands because it was a long-running, hard-fought case. So with that, I wanted to throw to Sam, because Sam is going to tell us that emojis can be defamatory.
Yes,
are there any cases?
Well, there are, and I think firstly, this is probably a question right up your alley, because I'm sure you're an avid emoji user and understand what it is. But there was a recent decision in New South Wales called Burrows and Hooter, and it basically had to consider whether an emoji could potentially convey a defamatory meaning. So the short answer is yes, it can. And I think this is really important because we're increasingly using social media, emojis, memes to communicate with each other, and sort of rely on communication to keep connected. So if an emoji is potentially defamatory, what consequences does that have for us? And the case is very interesting. It related to a Twitter thread about a lawyer's potential misconduct, and the defendant responded in relation to whether there was potentially disciplinary action taken against her. Responded with the zipper mouth emoji. Now, Brett, you know what that is? Basically, it's a face with the zipper mouth across the mouth, so pretty self-explanatory. And interestingly, the court basically said that there's a clear defamatory meaning conveyed, and they said it's generally used as a hierarchy type meaning. But more importantly, interestingly, the court referred to the emoji idiom, which is apparently a thing. I Google it myself. That gives you sort of explanations or as to what these emojis mean. So that was one of the bases for why they said that it was defamatory, but basically concluded that emojis can convey a clear defamatory meaning, which is quite interesting, and it's quite topical because one argument might be, well, on Samsung iPhones, emojis can sort of come up with different text or different symbols. So I guess the question is, can it really convey a defamatory meaning if there's sort of different possible explanations of what it is? So I thought that was a very interesting case. And you might say, well, how is this relevant to you or your business? But I think it's quite relevant because I'm sure everyone's been guilty of sending an emoji in an email to a colleague or a meme, which also potentially is a similar boat and could potentially convey a different meaning. So I think we really need to, as a business, look at social media teams, need to think about what's in their policies, but also before you send an emoji or an email, you have to really think, what is this emoji going to convey? Is there potentially going to be an ambiguous meaning to this seemingly innocent emoji post? So I guess it's something to keep in the forefront of your mind. A simple emoji could potentially land you in hot water, and you really need to, I guess, think before you send. And businesses need to ensure their employees are sort of really careful in how they communicate with customers or even colleagues. So yeah, very interesting case, and I think it's the first in Australia to deal with this sort of matter. So it'll be interesting to see where it lands from here. But be careful of what you emoji. Yeah.
I don't use emojis. By the sounds of it, though, Sam, in all seriousness, that seems a modern application of the discussion that occurs in some of those cases about defamatory or something being defamatory if it consists of a sign or a gesture by somebody. It just seems as though that's a logical extension of those earlier cases where, yeah. Okay.
Yeah, you just need to be more aware because, we use it all the time and you think you understand what they mean, but if someone takes it out of context, there's potentially sort of ramifications for that, which seems bizarre. That's how we're sort of leading, especially in this modern digital age?
I've just seen that some comments have come in. There's some echoing problems. That's probably my fault. I hope that people can hear me properly now without the echo. So my apologies for that. Okay. One question that is probably conveniently dealt with now that I've just seen pop up on screen. Question is, isn't it correct that a company cannot be defamed? The position there is, the short answer is yes, but subject to exceptions. The rule is that a company cannot sue for defamation unless it is able to bring itself within the definition of what's called an excluded corporation under the Defamation Act. What that means is that if a company has 10 or fewer employees and is not related to another company and is also not formed for public or charitable purposes, it can sue for defamation. If you can't bring yourself within the definition of an excluded corporation, under the current state of the law, the company has no defamation claim. It has other remedies, which, such as injurious falsehood or even misleading and deceptive conduct, but no defamation remedy. That is an issue that is currently being considered by the relevant Council of Attorneys General, with a view to seeing whether or not some relaxation of that fairly strict rule ought to be reintroduced. So hopefully that addresses that question. Sam, why do we need to distinguish between what's called primary and secondary publishers in the digital platform space? I mean, I know the traditional position pre-social media was a primary publisher would be somebody like an author or a journalist or even the editor or the actual publishing company that published the book that allegedly contained the defamatory material. So in the digital space, what is a primary publisher?
Well, a primary publisher in the digital space, what you're really looking at is if that publisher can have editorial control about what is posted before the content is online. And this is a very topical case, which we'll deal with a recent case later on. And I see we've had a question just about this, but the potential risk is that a business who owns a public Facebook page and doesn't vet comments before they're posted could potentially be liable as a primary publisher for comments posted by third parties on their own social media page. So I guess the really key issue in the digital age as to whether a person is a primary publisher is do they have the knowledge and control to stop effectively something that's published before it is published. So that, we're talking about online forums, Facebook pages in particular. So it's definitely, we've seen a shift in that definition of primary publishers.
So traditionally, in the pre-social media area, a secondary publisher was somebody like a bookseller or a newsagent or a librarian who sold a book or sold a newspaper that contained defamatory material. Do we have any examples of who might be a secondary publisher in the digital space?
Yeah, we're looking at sort of any platforms that host that really disseminate the content, such as search engines or internet service providers. And again, there's been a lot of debate and topic on this as to whether, for example, Google is a primary or secondary publisher. So I think that's probably a good topic to discuss next. Right. What is Google, a primary publisher, a secondary publisher? So Brett, what are your thoughts on that?
Well, not a matter of what I think. there's a very interesting case involving a Google and a lady by the name of Duffy. Dr. Duffy was a person who was basically looking for a partner, and she, rightly or wrongly, decided that she would consult with some psychics who told her, apparently, that she would find love, and told her, you know, the particular characteristics of the person who would be her partner. Perhaps not surprisingly, those predictions didn't come to fruition. Dr. Duffy became very annoyed with that and started to publish things that basically said psychics and people like that were rip-offs. Charlatans, don't trust them. So, perhaps not surprisingly either, some of the psychics and others responded to Dr. Duffy's criticisms, and some critical articles about her were published on a website called the Rip-Off Report. And those publications were also republished on various other websites. What Dr. Duffy complained about was that if somebody Googled her name by typing her name into Google's search bar, the search results would return hyperlinks to the defamatory publications, as well as snippets of the articles. And additionally, Google's autocomplete function suggested that search phrases associated with Dr. Duffy could be looked at, and they were said to be defamatory, and they probably were. So Dr. Duffy asked Google to remove the material and to change its settings. It declined. So she commenced defamation proceedings against Google. Google defended on the basis that it was entitled to what's called a defence of innocent dissemination. And we're going to sort of cover that a little bit later on in more detail. But it said we're entitled to rely upon the defence of innocent dissemination because we didn't and couldn't reasonably have had any way of knowing that the defamatory articles were being published as a result of somebody using a Google search and using the autocomplete function. They also said, well, we've got no control over the search result algorithms that we use. And it also said, well, we didn't authorise the publication of this defamatory material, so the algorithms automatically produce the results, so how can we be liable? So the court rejected Google's arguments. The reason they rejected the arguments was that the court found that, okay, then perhaps Google couldn't be liable right at the start, but once they were put on notice by Dr. Duffy that the material, that this defamatory material was being published as a direct result of the Google search function, it couldn't rely anymore on the innocent dissemination defence, because it hadn't, according to the court, innocently disseminated that material. So what that meant was that Google was held to be liable for the publication of the material. And that was a decision that was reached with, or received with some level of disquiet by Google, but it represents the current state of the law, at least in Australia, for defamation. So, Sam, we were talking before about the distinction between a primary or a secondary publisher. Why does it matter?
Well, Brett, the distinction is actually very important because if you are found to be a secondary publisher, you can potentially rely on the defence of innocent dissemination, which Brett was just briefly discussing, whereas a primary publisher, you can't. And the reason for that is as a primary publisher, there's, I guess, an irrebuttable presumption that you have knowledge of the content of the matter before it is published. Whereas a secondary publisher, you can try and prove that you neither knew or ought to have reasonably known that the material was defamatory. And one of the points Brett raised was really important, that as soon as you're made aware that a potential post or comment or whatever it may be is defamatory, in order to avail yourself of the defence of innocent dissemination, one of the key things you need to do is remove that material as soon as you're made aware of it.
So that probably leads into, because I think there was a matter involving that young fellow Dylan Voller.
Yes, a very interesting case and very topical. And this also leads into one of the questions we've just received, which is an organisation exposed to a claim of defamation for the comments of users and not the organisation on their social media platforms? Well, the case of Voller, it was a 2019 New South Wales Supreme Court decision in Voller and Nationwide News and others. And basically, it was the first time, again, that the Australian court had to consider whether a company can be considered a publisher of allegedly defamatory material when comments are posted by members of the public or third parties on their Facebook page. So this really, we'll talk about the facts in a minute, but it puts the onus squarely on the administrators of public Facebook pages and forums to really ensure that they monitor their page and comments as best as they can. Now, the facts of this, Dylan Voller, he received, as we said, widespread attention for his treatment. He was a detainee in the Dondale Youth Detention Centre in Northern Territory back in 2016. And this actually led to the Royal Commission on Youth Detention in Northern Territory. So as you can imagine, there's a lot of widespread attention, news articles floating around, and of course, newspapers, media outlets jumped on this and included links to articles on their public Facebook pages. And interesting, well, not interestingly, but not surprisingly, members of the public commented on those public Facebook pages underneath the articles, and some of those were allegedly defamatory. Now, Dylan Voller actually commenced defamation proceedings against the media outlets, and those were Nationwide News, Fairfax Media Publication, and the Australian News Channel. So he was alleging that the comments were defamatory. And I guess in these quite unusual circumstances, the court had to consider, and I'll make the reference here that it was a preliminary issue to be determined, and in that case, they didn't have to decide whether the material was actually defamatory or not. But this was the question they had to consider: whether the plaintiff has established the publication element of the cause of defamation against the defendant in respect of each of the comments made by third parties that were allegedly defamatory. So Brett, did you want to maybe talk about what the media outlets, what they said their defence was?
Sure. Yeah, happy to, Sam. I do remember the Four Corners program, which contained those horrible images of the treatment that was being received by some of these detainees. The news owners said, well, look, we're just a passive medium. It's not reasonable or practical to expect us to moderate each and every third-party comment that's made by somebody before those comments are posted on our public Facebook page. They said, we've got no control over the contents or the comments. We've got no prior knowledge of these comments before they're posted, and we've got no ability to require people who want to post to seek our approval before they put something up. So it sounds to me like an entirely understandable argument, given the way these Facebook pages, public Facebook pages operate. What do the court do?
You'd think so, Brett, but surprisingly, and sort of what caused outrage against many of the media outlets, the court found that those media outlets were liable as primary publishers in defamation. And it's interesting, the court had really two aspects to this reasoning. Firstly, The fact that the news outlets were administrators of public Facebook pages, and that's really a key, and we'll discuss the difference between public and private Facebooks a little later on. But those administrators basically can control what comments are posted before they're posted on the page. And they can do that by filtering comments via preset filters, and that might be using certain keywords to prevent them from popping up as comments. The other thing that you can do is hide all comments before they are reviewed, so before they're posted, until someone has actually reviewed and authorised those posts to come up. Now, I know the media outlets basically said, well, this is just completely outrageous. Who has, we have so many articles and thousands and thousands of comments posted each day. It would nearly physically...
Could I interrupt? Could I interrupt? That sounds to me like it might solve the unemployment problem in Australia.
Potentially. Well, I forget what statistics they said, but they said in order to have someone full-time looking at every single post or comment before it's posted would just basically be physically impossible. But unfortunately, the court held that it doesn't matter the fact that they didn't do this, but because they had the ability to control what was posted before it came online, that was enough. And it wasn't enough to sort of say you're willfully blind. And basically they said they had wholly control of what was posted on their page. So that was really sort of the main key aspect. And they had a lot of evidence about the Facebook pages and how it works. But the other aspect was, and this is something that I think all businesses need to consider before they post, is that this issue was such an emotive issue that the media outlets surely should have reasonably foreseen that this was going to cause widespread debate and potentially defamatory material to be posted online. And in that circumstances, even more so, that they really should have reviewed all of their comments before they were posted online, which they didn't. So they were really the two main aspects as to why the court held that they were primary publishers for defamation.
So the court also seemed to place a bit of emphasis on the fact that these public Facebook pages that were run by the media organisations, they were designed essentially to get content onto the pages and to earn some advertising revenue based upon the number of users who actually, went on and posted a comment. So I can see some real problems there in terms of the actual costs, let alone the logistics of monitoring, what can be thousands and thousands of comments, particularly, as you say, on an emotive issue, not just this, but there's plenty of other issues that are likely to provoke some fairly strong comments. So would it have made any difference, do you think, if the media organisations weren't earning revenue, or weren't, as part of the reason why they're doing this was to drive traffic to their Facebook page?
It's an interesting comment that Brett's made, but I don't think it would have made much of a difference, because the court in the Voller case basically said owners or administrators of public Facebook pages wholly have the control of stopping comments before they're posted. So I don't think it would change if it wasn't sort of seeking advertising or using that as a primary purpose, because at the end of the day, they have the ability to stop it, and they didn't. And that was really the key decision that the court made.
All right, well, I know that the media organisations and others who weren't even party to the proceedings lodged an appeal, and although they had some partial success, the primary finding of the trial judge, or the judge at first instance, hasn't been overturned. So, not surprisingly, the media organisations have decided that this matter should be taken to the High Court, and recently, the High Court has granted what is called special leave. That is, the High Court has agreed to hear the case, and the actual case itself obviously won't be heard for several months, but the decision of the High Court is going to be very eagerly awaited by a lot of media organisations and companies, businesses that actually operate these sorts of public Facebook pages. So the jury's still out on that, but watch this space, I suppose.
Yes, Brent, you made an interesting point before about the time and expenses a business might have in monitoring these comments or social media platforms. And I think that's really something that each business needs to weigh up the risk. Are we going to take the risk to not monitor or approve posts on social media pages before they're posted? Or do we not want to risk the potential liability in defamation and do that? So I think it's really important, especially in social media teams, you have to really sort of talk about what the best strategy is for your business, and whether that's just a constant monitoring of comments on social media posts or online forums, or I guess what we discussed earlier was at the very least you should be taking complaints seriously, and if someone posts something that is potentially defamatory, you need to remove it straight away. So something, businesses need to sort of decide internally how much they're willing to spend on this and how much risk they're willing to take when using these digital platforms.
So the administrators of public Facebook pages actually have the ability to be able to monitor and control the content. The question is whether they ought to do so in order to avoid liability under defamation law, and that's what the High Court is going to have a look at. Okay.
That probably, Brett, leads us into, and this was another question we had, is what's the difference between public and private Facebook pages? And this was discussed a bit in detail in the Roller case. Publishers who have the capacity to remove or hide content but only after it's published, is generally going to be held a secondary publisher, not the primary publisher. And that's what we've been discussing a bit in detail today, the difference of sort of knowledge and editorial control before something is posted. Now, apparently with private Facebook pages, there's different features, and this is something I guess businesses might need to consider, because potential ramifications of using a public Facebook page over a private Facebook page may be quite serious. So with a private Facebook page, an administrator cannot block all comments on their page, so they're really unable to exercise their editorial control except by the comments they make themselves. Secondly, there's no function, unlike public Facebook pages, or the ability to vet comments before they're posted. What you can do is, once the comments are posted, you can retrospectively go back and delete those comments. That's really a key difference between private Facebook pages and public Facebook pages. It's private ones, you can't do anything before the comments are posted unless you sort of block that person, but again, that's really in hindsight. So I think this is, again, really important for businesses who have private Facebook pages or employees to continue to monitor your Facebook pages, and as soon as something comes up that could potentially be an issue for you, you need to take active steps to remove it promptly, because as we discussed earlier, this could potentially allow yourself to be defensive dissemination, which is what you really need to do, to take steps to try and use it, and if in circumstances you're found to be a secondary publisher. Firstly, you publish the matter merely in the capacity or as an employee or agent of a secondary publisher. And secondly, that you neither knew or ought to have reasonably known that the matter was defamatory. And lastly, your lack of knowledge was not due to any negligence on your part. So really, to rely on that defence, and we've discussed this briefly, that you really need to promptly remove any defamatory material that comes to your attention. And this one way you might be able to do that is, as we discussed, use a private Facebook page over public Facebook page. But again, there's constraints to that, and larger organisations, it might be difficult to do so.
I have recently acted for the administrators of a private Facebook page who have been accused of being responsible for the publication of defamatory material on their Facebook page. Not unexpectedly, we're defending the allegations and have said that we're not responsible for them, but it's a very real issue, and these are just two individuals who, without breaching any client confidentiality, they're owners of a body corporate, or they're owners in a body corporate scheme down the Gold Coast, who have some concerns about the resident caretaker manager and how he is performing his duties. So they've set up this private Facebook page where a lot of other disgruntled owners are taking the opportunity to have their say. Yes, it's unfortunately the clients concerned have decided, well, look, there's just too much risk here, and they've just shut it down. Now that's a decision that they could make because they were doing this in a private capacity, but it's not an easy decision for a business to make because it would be impractical to implement such a solution.
Yeah, exactly, and that's a good point, because that probably leads into one of our questions that is quite popular we received from someone, and it really relates to not so much private Facebook pages, but reviews, Google reviews, TripAdvisor reviews, public Facebook page reviews from disgruntled customers. So I'll just read the question out. It says, how does a tourism business protect itself or respond to negative and vexatious posts and statements from the travelling public? In the caravan park sector particularly, it is becoming increasingly common for guests to stay a few days and then fabricate a complaint, demand a refund or a free night or more stay. If the park says no, then the guest threatens to place a very negative post about the park in various online forums. Could this potentially be seen as a form of extortion? And how can the park respond? Now, I guess, this is very topical because we deal with quite a few clients that potentially receive bad Google reviews or online reviews, and unfortunately the easy answer is there's not really one. I guess some of the steps as a business, firstly, what you need to take is, as we've discussed, if it's a Facebook page, you need to consider vetting comments or monitoring those comments as best you can. But when we're talking about Google reviews and TripAdvisor, it's really a little bit harder because you have to, in most cases, deal directly with Google, and I know we've dealt with Google a few times and successfully be able to have reviews posted, but it's not easy, and at the end of the day you might have a bad review sitting there for everyone to see. So Brett, what else do you think a business can do to sort of prevent this from happening?
Well, I tend to be of the view that in some instances it's just appropriate just to not respond at all, and hopefully the issue dies through lack of oxygen. I realise that that's not practical in every case. I know why this particular question has been asked, because we act for several caravan manufacturers in particular, some of whom have probably been the victims of a website called Lemon Caravans or some such thing. The law of defamation does provide a remedy. In fact, the administrator of that particular forum was actually successfully sued by a caravan manufacturer and ordered to remove some comments that had been published on the Lemon Laws or the Lemon Caravans website. So it's a case, I think, of assessing each case, each fact and circumstance, and deciding whether or not you're going to escalate the issue. You're right, though, about the difficulties with getting Google and Twitter to remove disparaging online reviews and the like. The landscape is changing, though. I mean, 2 or 3 years ago, it was next to impossible to get Google or Twitter or Facebook to respond to anything, because you'd just be met with the standard defence. Well, we're based in the United States. We're not subject to Australian defamation law. You can sue us if you like in an Australian court, but we've got no real presence here. And when you try to enforce the judgment in the United States, you're met with the freedom of speech defence that is protected by the US Constitution. So it's very difficult. But as with as I say, the landscape is significantly changing, and we're finding a bit more cooperation from some of these organisations about removing disparaging online reviews and other material. If you wanted, though, to escalate, well, we can assist. And another option that is potentially available is, a lot of times, unfortunately, people who post these things shield behind the cloak of anonymity that the internet provides. The person who's the victim of the disparaging review or comment doesn't necessarily want to commence proceedings against Google or Facebook. They want to know who's actually the person responsible. In those circumstances, you can certainly ask the online platform to provide all the details they've got about the account holder, with a view to identifying whether or not you can actually sue that person. A lot of times, though, the online platform provider will say we can't do that because of issues of privacy. Our terms and conditions say that we will respect the privacy of people who post. So that then leaves you with the option of having to go to court. You can go to court, and you can apply for an order that forces the provider to cough up details. You're not without remedy there, and you will often find, or in some instances you'll find, that the platform provider will not oppose the application. They just need to be able to demonstrate to all their users, well, look, we've respected the terms and conditions of our privacy policy. However, if a court orders us to disclose it, that stuff just goes out the window. So there are options, but it's unfortunately more complicated than it should be. One thing that is being looked at the moment, this is part of the consideration of a suite of defamation law reforms that are being that have actually been reduced to legislation. The New South Wales Parliament has actually already passed these laws, but they don't come into effect until the other parliaments get around to passing their own laws, because we want to have a uniform defamation law, not one that's specific to individual states. So, the situation is changing, but it illustrates, I think, the reason why businesses, not just the big online platforms, but businesses need to be careful about material that's posted on websites or Facebook pages that they control.
Yes, I think again this just highlights the fact that businesses really need to weigh up the risk of the potential costs and trouble involved into sort of dealing with these people, especially if you don't know who they are, if they're anonymous posts. So you really have to weigh up, is it worth going down that path, or should I offer a refund, or should I try and respond do what I can to try and fix it amicably as best as possible before going down that path. Because it certainly, as Brett said, does get complicated, and it's unfortunate for businesses because they're sort of stuck in between a rock and a hard place as to what to do sometimes. So again, just another important factor for businesses to consider how they go about using social media platforms and other digital platforms.
Okay, I'm now audio back on. Given the time, we probably do need to wrap up with some key takeaways that we'd like people to consider. One question that has come in, which I can deal with now. There are others which we haven't had the time to deal with, but rest assured that we will separately respond to those questions. We've been asked, can we clarify if our comments apply generally or only in Queensland? The position is that before 2005, we did have a hodgepodge of defamation laws that applied in specific states, and that led to what was called forum shopping, where defamation plaintiffs would sue in a jurisdiction which was most favourable to defamation plaintiffs. So the comments that we've been talking about today do apply to Australia, throughout Australia, and that is certainly, I don't see any going back to the situation that occurred before. Okay, Sam, what should people who've registered today, who are either involved in business or perhaps even post material on business Facebook pages and the like, what do we need to be mindful of, and what should we sort of take away?
Thanks, Brett. Yeah, I think businesses really just need to understand the potential risks and liability that they might have in defamation when using these social media platforms. And I think as a minimum, businesses need to ensure they have a proper system of responding to complaints and monitoring any complaints that come in, and most importantly, removing any sort of posts online as soon as they have any suspicions that it could potentially be defamatory. And I think, again, the other thing, and this is more to do with social media teams, but definitely businesses as a whole, and even employees using their own public Facebook pages or private Facebook pages where they've got colleagues or potentially clients on them. You really need to firstly consider what you're posting or what you're sending. Any emojis, maybe check the emoji PDR before you go about posting any emojis. Think before you send. I think that's a key issue, but really I think you just need to monitor social media as best as you can and think about those things we spoke about earlier. Can you vet comments before they're posted using a specific filtering system? Can you hide comments before they're approved by your social media or employees before they're posted? Or really, should you just have no comments at all on your social media posts? So I guess that's something, yeah, you just really need to, the key issue to take away is monitor your social media and digital platforms, not just Facebook, but any sort of online communications, even internal emails and group chats, messenger chats. There's so many different options these days, which is good for us, but also it's a catch-22 because there's potentially risks involved. So I think that's really the key issues we want you to take away. And we will be sending out a sort of take-home sheet that covers what we've discussed today. But of course, if there's any other questions you have, please feel free to contact us, and we're more than happy to discuss anything any further.
Thanks, Sam. So, legal issues like defamation maybe aren't or haven't been top of mind when that cursor is hovering over the tweet button. Social media might be instantaneous, but it's not as short-lived as we might otherwise hope. I hope that some of what we've discussed today serves as an illustration that online actions can have a lasting financial impact. So thank you very much for your attendance. As Sam said, if anybody else has any further questions that they'd like to submit, please do so, and we would be very happy to respond. I'm conscious that we haven't been able to respond to all the questions that we've received during the presentation. We'll get back to you on that. But thank you again, and we'll wish you good afternoon.